Hello, and welcome to the Nonfiction Authors Podcast, where we interview experts who help you learn how to write, market, publish, promote, and profit from your book. The podcast is brought to you by the Nonfiction Authors Association.com, which is the home of the Nonfiction Writers Conference.com. We have several membership levels, all of which offer discounts on our live courses and so many other benefits. Find out more at nonfictionauthorsassociation.com/join. I'm Carla King, your host, and I want to thank you for spending your valuable time with us today. Did you miss anything? Visit the Nonfiction Authors Association website to find all our replays with show notes, links, and transcripts. I wanted to let you know before we start that Joe has created 2 self-study courses for the NFAA. One is on legal issues for authors and the other is on book contracts. And we'll talk about those at the end of this episode. Thank you and enjoy. Hi there. Today's session is with Joseph Perry, and we're going to be talking about the fair use copyright rules all authors really need to be aware of. Let me tell you a little bit about Joe. Joseph Perry is a publishing attorney, and he's also a literary agent at the law offices of Joseph J. Perry, PC, and Perry Literary, INC, that's Inc., respectively. As an attorney, Joseph counsels clients in the publishing industry, where, among other things, he drafts, reviews, negotiates various publishing agreements, and conducts pre-publication review of manuscripts. As an agent, he represents best-selling cookbook authors, athletes, musicians, journalists, influencers, academics, so many more. And you can find out more about him at josephperrylaw.com or perryliterary.com. Hi, Joe. Welcome to the podcast.
Thank you so much. It's so great to be here.
Well, we need you because fair use violations is a huge topic. And I know in my talks with authors, we are discussing it all the time, whether we can use song lyrics, whether we can use quotes, poetry, whatever. So I'd love to start with those common violations, and then we'll talk about steps to avoid it when you can get permissions and licensing for words and maybe images that we want to use in our books. A lot of us are writing books that dive deep back into history, right? And fair use is just part of the bigger ecosystem of copyright law, which is kind of a huge tangled octopus thing, isn't it?
Oh, yeah. Without a doubt. Yes. Fair use is what I like to call the wild, wild west. So case by case basis, I wish it was easy. That made my job a lot easier.
The one I want to just give an example. I was working with an author who wanted to use quotes from song lyrics from a certain era under each of her chapter headings. For example, she wanted to use a Led Zeppelin Stairway to Heaven. She wanted to use the quote, "There's a lady who's sure all that glitters is gold, and she's buying a stairway to heaven." By saying that, did I just...
No.
Oh, okay, good. So she found out, I said, I think you should check on that. And she found out that she couldn't do that.
Nope. I mean, unless she got permission, but that's just insanely expensive.
She did. I have to say, she was able to connect with some of the band's representatives. And they said,
really? Wow.
It's $25,000 to use that quote, right?
Exactly.
So where is the line here?
So it all depends. So could I just take a step back and just explain what is fair use? I think that'd be a good
Let's do that.
Sort of segue and then get into that. So you can you need the context beforehand. So courts look at 4 factors. It's from Section 107 of the Copyright Act. For any copyright nerds out there, you can actually look at the language. It's not going to really help you because it's vague. But factor 1 looks at the purpose and character of the use, and we'll get into transformative use, I assume, later on in the podcast. The second factor is the nature of the work, whether the work you're taking is creative or if it's factual in nature. Third, they look to essentially how much you've taken from the work, qualitatively and quantitatively. There's, I think, a misconception that I've only used a few lines or I used 10% of the work. It really is a case by case basis. And then 4 is the effect of your use on the market. Could you have licensed that work? If you could have licensed it, it can be a factor against you. This is where it's tied to purpose. where, if you are using it for research purposes, or like, I'm making this up, you made a PowerPoint presentation for, a private party you're having with friends about whatever topic you're talking about, that's likely not going to be risky. But if you're using it for commercial purposes, so to get back to your question, and, the problem is, yes, you can get permission, but it's just going to be so expensive, and you just have to think about who you're dealing with. I mean, music. I used to work at Sony Music before publishing, and they're, people in the music industry are just notoriously litigious. They're very protective of their intellectual property,
except for the Grateful Dead, right? I mean,
yes, exactly. Exactly.
They're like, go for it, take anything. Yeah, they're amazing. Exactly.
They're like the open source
apart.
Yeah. So with that in mind, like, if you're going to use the most famous lyrics of that band's, arguably of that band's repertoire, it's going to be incredibly expensive, even if you are using a line or two. And this gets back to sort of how you're using it, the purpose and character. They're essentially asking, why are you using this work? What are you doing with it? The whole point of copyright law is to progress the arts and the sciences. So what are you doing with that work? With whatever you're taking? Are you just copying and paste it because it has some sort of vibe to your novel or book or whatever it may be? Or are you actually are you bringing in that content so you can educate the reader? You're evaluating the lyrics, you're analyzing. This is where transformative use comes in, which is essentially giving new meaning and new utility to a work. The easiest example I give is, I go back to our research papers in school. You took a source, you put it into your paper, and you evaluated it towards, whatever argument you were trying to make. The same thing goes for things like song lyrics. You're going to have a much easier case to say something is fair use if you're writing a critical biography of Led Zeppelin and you're analyzing those lyrics, compared to if you just want to use a lyric or two underneath your your chapter titles, or if you put it in the epigraph page. You're not really doing anything with it. It's cool, but you're not really progressing the arts and sciences. And again, when it comes to lyrics, the music publishers are just very, very litigious, and you're going to have to pay a lot of money. So what people end up saying, especially for like novels, is make it up. I know that may not be what you want to hear, but that's the easiest way to not have any issues, or make sure it's in the public domain, or try to get permission. If you can't, then or if you strike out, or if you can't contact them, you can try within fair use, but there are just certain ways that you can use the content. And I think it's not to say that if you use it in that particular way that person wanted to use it, that it's automatically not going to be fair use. But I think there's just an argument to be made that it won't be. Because that's what lawyers do. We try to predict. So it's not an exact science.
Which is tough, I know. And I have gotten so much pushback, even in classes and stuff. They're like, well, okay, but in my memoir, the band where my husband proposed to me was singing Stairway to Heaven. So why can't I do that? Or the person, who was standing next to me was singing those lyrics.
Right. I mean, what you could use song titles. That's perfectly fine.
Yes.
Those aren't copyrightable. Now, some titles are trademarked. So something like Stairway to Heaven, I imagine, is trademarked. So you may have an issue there. But I think you might have a good argument to say, like, just this, someone was singing the song Stairway to Heaven, at a restaurant, or not restaurant, at a club, or wherever.
Sure.
Yeah.
Okay, so say you've already done it. I know there's some authors out here who might have already done that in their books. How likely is it that, the copyright owner is going to come after them? How do they tell? Are there like internet spiders and Kindle spiders that go and look at that? Sometimes,
yeah. There are some companies have software that essentially lets them know. So, and I don't know who's doing it, who's not doing it, but the fact that that's out there, I think I don't want to say it's going to chill expression, but it's definitely going to stop people from doing it. So it's out there. So if you want to just be careful, just if it's in a novel, make up the lyrics. It's not only going to be my counsel, it's what your editor is likely going to say as well, unless the lyrics are in the public domain.
Right. Oh, good. So
Mhm.
editors largely know about this stuff.
Mhm.
That's good to know. All right.
Yeah.
Hire a professional editor.
Yes.
So what about, let's say I'm writing, I want to put a line of Byron's poetry. Is Byron's poetry out of copyright? How do I find out?
Yeah, it's in the public domain. So great resource. Just Google Public Domain Day. Duke Law School has this great resource. And I believe now it's either 1926 or 1927. Anything before that is
Public domain day. So that reverse, it's like when you're buying liquor at the grocery store, the cashier's looking at your driver's license date. Okay.
Exactly. It's every January 1. Yeah. It's every New Year's Day.
Okay.
We copyright lawyers celebrate because some works, I think like Great Gatsby is now in the public domain. I think The Sun Also Rises. But the resource is great because it's not just about books. It's like whatever they have, like it's sort of like encyclopedic of different types of creative works. So for like a Byron example, go ahead and feel free to use whatever Byron poems you want. However, with that said, it depends on the poem that you use in terms of where you're crediting the source. If it's a book that's published, you just have to make sure, like published, like I'm just making it up, say like last year, you have to make sure that you're essentially just taking the poem and not information that copyright owner owns. The information that copyright owner will own is their original selection and arrangement of information, whether that's how they express their opinions or analysis of Byron, essentially anything extra outside of the poems, they're going to have that. So you just want to make sure, or they're going to own that. So you just want to make sure that you're not taking more than what you need. So it's very layered, unfortunately. But generally speaking, if you want to use a Byron poem, go for it.
Okay, good. Great reference. Thank you. So for the authors who are doing critical work, I mean, what is under fair use? Like, when can I use the lyrics or the poetry? There
are certain favored. This goes back to the purpose and character in factor 1, and there are certain favored purposes that courts look at. And just as a caveat, just because it may be a favored purpose doesn't automatically mean it's going to be fair use. You have to look at all 4 factors. I tell to all my clients. So you want to do a complete analysis rather than stopping at factor 1 and saying, it's for education. That's, I'm sure, you may have a better argument to be made, but you just want to make sure that what you're doing is, you'll have a more complete analysis that way if you look at all the factors. So back to your question, favorable uses are like, a lot of them are written out in the statute. So in section 107, like research, education, scholarship, those types of things, criticism. Commercial uses are not favored uses, but essentially, and as we've entered the digital age and from the 20th century into the 21st century, it seems like every use is essentially commercial. So, but the same analysis goes for commercial uses, that just because you're going to say you want to use, like you said, lyrics in a book, in your book, that's for a commercial purpose, doesn't automatically mean it's not going to be fair use. You have to use the 4 factors first, or analyze the 4 factors first before determining that. So for like a concrete example would be, if let's just stick with Led Zeppelin, if you're writing a biography of Led Zeppelin, like a critical biography of them, and you're analyzing the lyrics and what they mean to the band, what they mean to rock and roll and to music today, you're essentially you're transforming the lyrics. You're giving the reader a new interpretation, a new new meaning as to how those lyrics fit into the greater, artistic world of rock and roll.
Even if you use it correctly, you still have to give credit. So how do you find out where to give credit? Do you have to do it right away, or are there bibliographical notes?
Yeah, I think it all depends on this goes more towards like the publisher's style and how because some people some books I've seen footnote it, Others, it's all the way in the back of the book, like in a bibliography. And this is where you'll be working with, presumably, if you're with a traditional publisher, you'll be working with their team to come up with their sort of the copyright page where if there's any permission that's used, I'm sure you've seen this.
Yep.
Permission is used by blah blah blah. X band.
Right.
Or,
permission is granted.
Artist. Yeah.
Well, I mean, there are a lot of people self-publishing now, and not all of them use professional editors. So I do want to, say that using professionals to edit your book is, as you noted, super valuable because they know about these things. But a lot of people just self-publish their stuff and then put it up, and they go, "Oh no!"
Exactly.
Yeah.
It's, the way I look at it is it's all a risk analysis. It's how much risk you can take. It's not to say that if you're very, very risky that, to hell with everything, I'm just going to do it. You may find yourself.
And I won't get caught. But now we have these spiders, and
Exactly. So that's why I always say, like, if you can try to transform the content, that's really the big factor. And the other big factor is the effect on the market. Again, if you're using it for like private use, it's not going like, if I were using Led Zeppelin lyrics in, I don't know, in an article that I was just sharing with friends, that's totally different than, if I'm writing it on,
But not on my blog post. I can use them in my newsletter, but not in my blog post.
No, that would be the same thing because this newsletter, you can be using it for commercial purposes.
That's true.
Yeah.
Okay. Careful, people. That's good to know. Thank you.
Just at the end of the day, make sure you're giving the reader a reason to see why you've brought this into the fold. Again, just think of like, are you progressing the arts and sciences here, or are you just copying and pasting because it's cool, or are you using it because you like the effect of something? That's not that's not enough. To someone say, or to me, for a court to say, yeah, sure, that'll be okay. You really have to bring something new to the table.
And this all goes back to this transformative argument that's happening. There's a big case, right? Do you want to talk about the Andy Warhol case and what it has to do with writers too? Yeah.
So, I mean, it's mainly in the art world. And just as if we can just, step back from that, just so we're talking about fair use here, mainly how it deals with text. But the question that comes up all the time is, what about artwork? What if you have to use the entire thing? With text, it's a little easier because you can just use snippets of text. But with artwork and photographs, it's a lot more difficult because you're using the whole thing. So with the Andy Warhol case, it's outside of publishing, but it could have implications for all types of art. And just a factual background, what happened here was that Lynn Goldsmith took a picture of Prince, I believe in 1981. And Andy Warhol was commissioned to essentially create silk screens based on that photo, which he did. I think he created like 16 of them. But what had happened was after Prince died, Vanity Fair used one of those silk screens as a photo on their magazine cover, I think to commemorate Prince's death. And she found out and she sued for copyright infringement. And the Andy Warhol Foundation wanted a declaratory judgment, which essentially says, I declare that this is not infringement. And the district court said that it was fair use with what he did. I wish I had a visual here, but you can just Google it. You'll be able to see exactly what I'm talking about.
Maybe I'll put a visual in the video version of this on YouTube. Great.
Sure. So, but then what happened was that the Second Circuit reversed the decision and said, this isn't fair use. You're actually infringing on Goldsmith's derivative work right. This isn't transformative. So now that's at the Supreme Court that just had an oral argument a couple months ago. So we should be hearing the opinion. It's hard to say what may happen here. It seems like the court is favoring Goldsmith because they're dealing with the vague language of transformative use. They're essentially asking themselves, is it transformative? Is it enough to say something is transformative if something has new meaning and new a new meaning or a new message. That may work for some things, but others, you're going to have issues. Like, for example, for, all writers here, if you were to adapt your book into a film, right now you get paid for that. You get an option, and, they pay you to use your intellectual property. If a court were to come back and say, that is fair use, that's going to essentially give Hollywood a windfall. And so they're wrestling with what to do, whether to say if it is transformative use. I think they're going to actually side that it's not transformative use, just based on these concerns that I was just mentioning. But the implications are really big, because if they do come up with a new test, everything that I'm saying here may be for naught, just because there may be a new test. However, the court may essentially remand the case, because what I didn't mention was that they only looked at the transformativeness of the use. They didn't actually look at factors 2, 3, and 4. So they may actually push it back down to the lower courts to look at factors 2, 3, and 4. So it's a lot. There's a lot writing on this, and even for art as well. A lot of people are saying, how is this not fair use? It's Andy Warhol. This is what he does. If this isn't fair use, what is? So it depends on the side that you're on. But there are a lot of implications, because this is really the first time since the court has taken up a fair use case based on artistic, what I like to call merits, since 1994. So it's a really, really big deal. So I would definitely look out to see when this is published, to see what they do. I'd be very surprised if they suddenly turn around and come up with a brand new test, but they were wrestling with that in the oral argument, what to do, what type of test. They didn't like what the parties had suggested if they were going to have an alternative. So at least that's what it seemed to me. So it's a big deal, but it's hard to say what's going to happen.
Okay, well, we'll be watching that for sure. I'm seeming to remember that back in the days, it might have been Saturday Night Live or something, that somebody sued somebody for copying them or doing it a satirical work or comedy or humor. Mm-hmm. I can't remember what the situation was. But if you're writing humor or satire.
So for parody, you're bringing attention to the work itself. And that was the case that I was just mentioning, the one from 1994. It was Campbell v. A. Rose. And that was a parody of Roy Orbison's Pretty Woman. Two Live Crew wrote I forget the name of the song, but they wrote a parody of that. And the question was, what they did, was that copyright infringement or was that okay? And the court said that it was okay. And part of the reason why parody is protected is that you have to conjure up the original work for someone to know it's a parody.
I think that happened with Robert Palmer's Addicted to Love too, didn't it?
Mm-hmm. I think so. Yeah,
I remember that. Okay. Can you go over the 4 factors again? And sure. I'm reading them, but I don't quite understand them because they're they're kind of in legalese.
Welcome to the world of
so the first
confusion.
I know. So the first one is the purposes and character of the use, including whether the use is primarily commercial. Mm-hmm. In plain English.
Yep. So that's essentially, why are you using this work? Are you using it for a commercial purpose? Are you not? And there's the preamble before that, which states the more favored purposes. So that's what, so essentially factor 1 looks at why are you using it? And then within that, it doesn't say that in the language, this comes from the cases. And really this, the Supreme Court who came up with the transformative use, analysis. Have you transformed your work, the work that you're using? What are you doing to give it new meaning, new utility? What are you bringing that's new here rather than just, essentially, I don't want to say copying and pasting, but essentially doing that.
Just making everything look cool, making yourself look cool.
There's got to be a purpose to it. Exactly. Okay. There's got to be a whole purpose. And that's really what the courts right now, the Andy Warhol case, that's what they're arguing about. Mm-hmm. What is purpose? What is character? How are they different? Mm-hmm. And, it just goes towards, what they may be thinking about in terms of the new test. Factor 2.
Okay, I'm going to read that.
Oh, sure. Go ahead.
Okay.
Yep.
It says the nature of the copyrighted work being borrowed from.
Mm-hmm. So the nature of the copyrighted work looks to see whether your work, the work that you're taking from, is factual or creative in nature. And there's a big difference in terms of what's protected and what's not. Factual works are less protected. And that is because as a society, we need factual works to be out there. Courts look at factual works by essentially saying they're going to educate us. They're going to make us better people. So they're not going to be as protected. Creative works, on the other hand, like a novel or a nonfiction book, this goes towards like the legislative history of the Copyright Act and how essentially politicians have viewed authors. And with creative works, it actually goes back to like even some theories within like literary theory, like for all the English majors out there, in terms of like what is an author. That's been a huge question.
Like you have to go back into Foucault and Derrida and all of that. Yes.
Yeah. So there are. That's why I like to bring it up, because there are connections there. Where I remember I was studying literary theory. Like, when am I ever going to? It's interesting. When am I ever going to use it? But in this instance, there are connections. So they're asking, what is an author? And they look at the author as like this sort of like romantic, mythic figure who's created something out of nothing. So you've created a novel, you should be celebrated for that. You've created a song. It's really amazing that you're able to do that. I mean, that's really, layman's terms, but that's essentially what they're getting at. And they protect creative works more so than they would a factual work. And that's part of the reason why they do that. And also, even though it's not mentioned in the statute, courts also protect where you're going to publish your work first. They want to make sure that you are in charge of where you want to publish first. So they protect unpublished works. Okay,
that was number 2. Number 3 reads,
I know, right?
Thank you for enlightening us. The amount and importance of the portion used in relation to the original work as a whole.
So this is where courts look at how much you've actually taken from the work, quantitatively and qualitatively. And this is where I say there's no bright line rule. It doesn't matter if you took 2 lines of something or even if you took a couple paragraphs. Context matters. It's a case-by-case basis. So that's the quantity. And then the quality, they look to see like, what have you taken? And a good example is case Harper and Row, which was a Supreme Court case from the 1980s. And what happened there was that President Ford wrote his memoir, and he was going to get it published by Harper and Row. And Time Magazine had contracted with Harper to essentially excerpt the work. I think it was like 7,500 words or so. But what happened was that the Nation magazine scooped Time and ended up publishing like only 300 words of the memoir. But what happened was that those 300 words were essentially why, if memory serves me correctly, why President Ford pardoned President Nixon. So even though it was only 300 words, it went to the heart of the work. So that's the qualitative portion of it. So they said, this isn't fair use at all. And you can imagine it's because someone scooped somebody else, like it was just like a bad faith move. You can just guess that they weren't going to win. But there's that qualitative nature. So whatever you're taking, look to see not only how much am I using, but what am I actually taking? Am I taking like the main portion of this work? So that should go into your analysis as well. And this is where they ask, well, could you have licensed it? If the answer to that is yes, that factor will go against you. But this also goes towards this also goes towards purpose and how that's tied in. So like if you're using it for research purposes, more private purposes, there may not be a huge effect on the market. But if you're using it for commercial purposes, writing a book, trying to sell it, publish it, that's probably going to be a factor against you. So then what happens is that the courts, or well, really, I guess the judges, or if you're not even at that stage, lawyers like me, we look at all 4 factors in totality and then determine whether or not something is going to be fair use. It's on a case-by-case basis because courts have not followed precedent. So that's why it's so context dependent. So when I get questions in general, I can't answer them because I need the context behind it.
And the context is changing with technology, and we can't even address the whole AI mess here and what that's doing to transformative works and writing bots and things like that. But that's super interesting. Well, I mean, there's enough here. I mean, fair use is hard enough for authors. And thank you for providing guidelines for us. Really appreciate your clarification. And I'd love for you to talk about our course. We've invited Joe to create a small course, a flash course called Legal Issues for Authors. Can you talk about that? What do you cover?
Yeah. So fair use is part of this. So I talk about the basics of copyright law, trademark law, libel, right of privacy, and right of publicity, which is a form of right of privacy. And fair use within the copyright area, and how that affects writers, publishers, editors. It's really like a 101 type of class. I actually have another class as well, a flash course on book contracts as well.
Oh, so, yay!
Yay! Yeah. But for our purposes today, the legal issues for authors, this is just a portion of the course itself. I think it'll be really helpful.
It will, and libel and slander is also a popular subject, especially for memoir. Yeah. Thanks again for being our guest today, and thank you to our listeners for joining us today. This podcast live streams weekly with monthly top replays from our archive of over 400 interviews. Find out how to listen or watch at nonfictionauthorsassociation.com/podcast. And while you're there, please sign up for our mailing list to get reminders and all kinds of good stuff nonfiction authors need to write, publish, promote, and profit from your books. Until next week, keep writing. The world values your experience and expertise. Hey, just a couple more things. I want to give a shout out to our awesome sponsors and partners, which you can find in our resources section, along with a huge list of experts who can help you with every aspect of your publishing journey. Thanks again for your time, and please join us each week by subscribing to our YouTube channel or on your favorite podcast audio app.